today it's a real pleasure to have Peter Henderson, who is a JD PhD candidate at Stanford. He's going to be telling us about a topic that is of great interest to many people, which is the connection between fair use of data and foundation models.
Thanks so much. I'm a JD PhD candidate. My PhD is in machine learning. And I'm also on the law side at the Stanford Law School. So I'm going to try to bring together the two different areas to give a little bit of perspective of how different technical techniques interact with sort of the fair use analysis and give you an overview of both the law side and the technical side on how these two things interact. So I want to say a lot of this work is done with wonderful co-authors here on the screen, both at the law school and in the sort of machine learning side of things. And I should make a disclaimer, which is sort of the standard law school thing to do, which is the views expressed in this talk are my own, not of my co-authors, and none of this is legal advice. So you may have heard a lot of buzz about foundation models. Foundation models are useful for tackling a lot of impactful decision-making problems, a lot of problems across a wide range of areas. If you don't know what a foundation model is, you can also think about it as a large pre-trained model. So you take a lot of different data from all sorts of sources, you train on it using self-supervised learning or some other technique, and then you have this model artifact that you can then fine-tune quickly or adapt quickly through different techniques to a lot of different settings downstream. And so foundation models fundamentally train on copyrighted content. And this is a little bit unavoidable, and I'll tell you why in a second. But for example, a commonly used data set called the pile is trained on, for example, Common Crawl, which is a snapshot of the internet. It's trained on GitHub, so various code bases. And it even has a BitTorrent tracker in there that was downloaded and has all sorts of books, right? And these include very popular books. And so the reason that it is sort of unavoidable that foundation models train on copyrighted content is because any work is under copyright protection the moment it is created and fixed into tangible form. So basically, as soon as you put it down on paper, as soon as you put it into your hard drive by typing it out, it has copyright protection. So that means anything on the internet could have copyright attached to it, and similarly for all sorts of other data. And so it's a little bit unavoidable that you will inevitably train on some sort of copyrighted material. The challenge is that foundation models have also been shown to regurgitate some of the training data. Myself, others have shown this for private information, hate speech and toxicity, copyrighted content, all sorts of things can come back out if it's in the training data, right? And so this is a challenge because this can result in legal challenges on copyright infringement grounds, right? You train on copyrighted data, you might not know that there's a license to it, and then you output that material. And so that is a potential risk when you have foundation models, because fundamentally foundation models are about training on lots and lots and lots of data to make sure that we can quickly adapt to lots of downstream settings. But in the United States, fair use doctrine, which is a legal doctrine that I will explain to you in a second, allows you to use this copyrighted material without a license under a certain set of conditions, right? And so this means that you can train and you can have models that generate content, even though you're trained on copyrighted material, under certain conditions. And so sort of throughout this talk, I will explain to you how those conditions could or could not apply to foundation models, how we can use technical strategies to prevent some of the potential risks from training on that copyrighted data and making sure that things are in line with fair use. And then what are some law and policy considerations that we might want to think about going forward that interact deeply with those technical mitigation strategies. So what is fair use? So fair use is a law that has 4 parts to it. So when you do a fair use analysis in law, it means that you're considering 4 factors. The purpose and character of the use. So that means effectively transformativeness of the new work compared to the original work. It is the nature of the copyrighted work, so factual content is less protected versus creative expression. And then the amount and substantiality of the copied portion. So basically how much of the original work did you take? And then the effect on the market for the original work, right? So did you sort of replace the original work when you created this derivative product? So I'll mostly focus on transformativeness, though all of these are very important. But the reason to focus in on transformativeness is that it has been shown to be sort of a very important factor according to recent empirical studies. So courts take into account transformativeness a lot, focus in on this first factor, though the other factors are important as well. And you'll see from case to case sort of a combined analysis that shifts around in terms of what emphasis is placed on which factor. But we can get a good sense of what it means to have transformativeness by looking at past cases, right? So in the common law system in the United States, you want to take a look at the past and see what kind of outcomes courts had to inform how you might think about fair use in the future. And so I'll go through a few cases, but you can think about, for example, when you train on books and then you have a transformation to a bunch of different downstream tasks, there's sort of relevant cases that can help us think about the model and how it transforms the training data into outputs. And so as I talk to you about these different cases, keep in mind sort of what is the model equivalent, and then I will get to some examples for generative foundation models for thinking about how these cases might map on to those. So let's start off with Gerald Ford, who is the president of the United States. So Gerald Ford had an autobiography that had not been published yet, but was written. And Time magazine licensed 7,500 words or thereabouts to print sort of a periodical to reveal this compelling story about how, Gerald Ford's presidency, how he pardoned Nixon, all these sort of really exciting reveals at the time. And Time magazine licensed that material to sort of create a series, a special series on it. Another magazine called The Nation got an unauthorized copy of the autobiography ahead of time and basically scooped Time magazine, right? And so they used about 400 words, sort of between 200 and 400 words of the exact quotes from that autobiography and published an article about it, right? But there were some key sort of quotes that revealed really interesting information about the Nixon pardon that basically made the Time magazine issue not as compelling anymore. And this created some damages to the potential market for that magazine. And as a result, the publisher sued the Nation magazine, and Nation tried to rely on fair use, saying, well, look, I only used 200 to 400 words. It's just quotes. This is what you would do for any sort of review. But the court said, no, this is not fair use. Even though it's only, a few hundred words of a very long biography, these were the really revealing quotes. These were the heart of the book. It really impacted the market, right? So when you think about transformations, even a few hundred words can create problems when you generate or when you have derivative products like this, for example, The Nation. But on the other hand, we can have Google Books, right? We can have search, and we can have snippets of books, right? We scan everything in, we make it searchable, and you can go online and, for example, search Gerald Ford's biography, the exact one, and get those snippets right now. And publishers sued Google for this, but the court sided with Google, and this is okay, right? It's a transformative use. Search is different than the original intention of the book. It doesn't necessarily mean that people won't buy the book just because they can search for particular snippets. And you've really spent a lot of effort to restrict the amount of material that people can access, right? You only get these very small snippets. And of course, hypothetically, a determined user could try to use all sorts of VPNs and like reconstruct the whole book that way, but it's very hard, if not impossible, to do that. And so the court sort of sided with Google on this front. But things get more complicated, right? Like, even if you have verbatim snippets, there's some cases where it is not fair use, some cases where it is fair use, depending on the level of transformation, the amount of content, and the importance of the content. But you can also have higher level transformations, right? You can think about creating all sorts of different content from that original work. So here's an example. I believe a Kickstarter was started for this book called "Oh, the Places You'll Boldly Go," which was a Star Trek sort of themed version of "Oh, the Places You'll Go." If you measure the n-gram overlap, there is almost no n-gram overlap for I believe 3 grams or 4 grams or above. And so there's very little similarity between the two works in terms of pure text. But nonetheless, the court said this is not fair use. There are too many similarities in terms of the structure, the messaging, the themes, the actual expression of the content between "Oh, the Places You'll Go" and "Oh, the Places You'll Boldly Go," right? And the cover actually looks quite similar, but if you open up the book, things get further apart. So there is this higher level semantic space where we think about fair use and say, well, actually, there's too many similarities here to make this fair use, right? And so it's not just about verbatim snippets, it's also about something more, right? And we can go even further, right? There's all sorts of fan fiction that has come about, and people read it and create it all the time. But there are cases where companies will pursue legal action against fan fiction. So, for example, there was a fan film called Axanar, I believe, and basically this was a Star Trek sort of fan fiction film that was created. It was not trying to hide the fact that it's Star Trek, right? It used a lot of the same costume design, set design. It even had an actor who actually was from Star Trek and appeared in this fan film. And so as a result, Paramount, I believe it was, pursued action against the fan film and said, look, you can't make a feature-length film that is basically a Star Trek film without us involved. And the court said this is not fair use, right? So because you're borrowing too much from that original material, you're potentially impacting that original market. And so eventually, I think Paramount decided that they sort of settled and said, okay, it's okay if you make 20-minute films that are only available on YouTube without ad monetization on the video, and then that's fine. But if you try to make this into a feature-length film, we'll continue with this action, right? So basically, it's sort of because you're borrowing so many elements for that original work, the company had the potential path to a successful action. Right? Similarly, somebody for Harry Potter tried to create a sort of encyclopedia, a lexicon of all things Harry Potter. Like anything you can imagine about the Harry Potter universe would be explained in this book. But then the J.K. Rowling and the publishers sued basically because there was too much of the original work taken to create these explanations. Right? There was too many paragraphs that were verbatim lifted from the book. There was too much material that was basically exactly as in the original work. And so, again, this is found not to be fair use because there's too much of that content from the original work, not enough transformation. At the end of the day, this version that you see on the screen was actually published because at the end of the day, they decided to transform a bunch of the material, make sure that it was not that it was transformative enough and not using so much of the verbatim material from the original source, right? I'm going to do a few more examples to really get you in the zone, thinking about how these fair use cases come about and how the courts think about this analysis, right? And this is just to give you some intuitions that will help us down the line think about generative AI. And so here's a game, a video game, NBA 2K14. So you have basketball players in this video game, and they've signed a license to use their likeness in the game. That's all good. But then you have their tattoos. So this tattoo that's on the arms of the players has been litigated, in fact, across different video games and different players and different courts. And in some cases, the courts have said, no, this is fair use. It's a very tiny portion of the video game. It's fine. There's also some discussion of implied license that I won't talk about here, but some courts have decided that this is not fair use. There is no implied license, and there actually had to be a payout to the tattoo artist for the use of their art in the game. And so this sort of split, where you see some courts decide it's fair use, some courts decide it's not, shows how sort of uncertain the landscape is, right? You can have these outcomes that are maybe a little bit unexpected one way or the other. And it also shows just like how a tiny portion of this image can create a problem in terms of fair use. Yeah, so there's a question whether some courts, I'm going to be talking about a US context pretty much the entire time. Fair use is a mainly US doctrine. Some other countries have similar doctrines, but yes.
So is this a circuit split that you're talking?
Yes, there's a circuit split, yeah. It hasn't been litigated all the way up. There's some theory that eventually it will start going all the way up through the courts, but it hasn't so far. And yeah, some other countries have a fair use doctrine. Israel has something a little bit similar to the US doctrine. Canada and UK have fair dealing, which is similar but different in many ways. And some countries don't have fair use at all, right? And so this is important to keep in mind that everything I'm talking about is for the US, and it's already complicated enough. And then when we get to other countries, things get a little bit even murkier than that. And so just keep the US context in mind. And so the final sort of case in the non-generative context, non-AI context that I'll talk about is the recent one where there is a Supreme Court decision that came out just in the last week or so, where there was a photo of Prince on the left. This photo was used as a basis for an artwork by Andy Warhol on the right? And so this was commissioned by Vanity Fair. Vanity Fair had a license to use the photograph, but then there was a bunch of different artworks that were created from it that weren't necessarily weren't covered by that license. And so basically, the photographer of the original photo sued the Andy Warhol estate and said, look, you had to pay me to use this photo and create these derivative artworks. Andy Warhol says, or Andy Warhol's estate says, this is fair use, right? I transformed the image into something totally different, a totally different message. It is very different, but the Supreme Court, as of in the past week or so, basically said, no, this is not fair use. This sort of transformation is not covered, but there was some complexity to the way the opinion was written. So we will see how it sort of plays out in different cases and how it updates the doctrine. But essentially, one thing to keep in mind is these sorts of transformations where you have the sort of original image captured in this different way might not be covered by fair use, right? Like in this setting. And so what does that mean for generative foundation models? And particularly the outputs of them? It means that there's some amount of risk. It's unclear what that amount is. We will see as things progress. But it means that there are cases that look a lot like things that you might see generative models create that might create some amount of legal risk for companies. And we are seeing that in terms of litigation now. I'll note that I'm only talking about outputs from the model right now, right? So we're comparing sort of things that are created by the model and any liability that stems from those creations. There's some question about the training process itself and whether that is considered fair use. Legal scholars have sort of argued that it is transformative and it is fair use because the model itself is this transformative product. But this has not really been tested in court. We will see if courts agree with this analysis. But I will focus mostly on the outputs and any liability that sort of stems from that and how we can think about that. So there's some questions, right? If foundation models can't generate copyrighted content, it's not really a problem. We don't really have to worry about this so much if everything they generate is transformative, right? But unfortunately, well, it's not really the case that that's true, right? So if you, for example, prompt ChatGPT with the first 4 lines of "Oh, the Places You'll Go" by Dr. Seuss, you get the whole book. This is true of other models as well. In earlier versions of ChatGPT, you could even put it into a state where it thinks it's a file system, and then you just do vim, "Oh, the Places You Will Go.txt," and it gives you the whole book. Right, so you can really get these models to generate content that is verbatim like that. Similarly, for prompting with the first few sentences of Harry Potter and the Sorcerer's Stone, with ChatGPT 3.5, we got about 3 to 4 pages verbatim. With GPT-4, we get 3.5 chapters verbatim. Anecdotally, just from this example, it seems like it's correlated with context length. If you look at the token counts for the 2 things that were output verbatim, it correlates a lot with the context length windows for the 2 models. So this needs more exploration, but it's possible that the longer context windows we have, the more potential risk there is for this sort of verbatim memorization. We did the study on a bunch of other models. We only had limited token access, so it's with a low temperature, and so you can probably do better extraction with higher temperatures and other techniques. But if you partition books along sort of random passages from random books, from the books 3 corpus, versus popular books that are all-time bestsellers like Harry Potter, the popular books are the ones where you actually get much more regurgitation, right? And I think there is a question. So I don't know if should we hold questions till the end or just
Up to you.
Okay, sure. Yeah, go for it.
Is it okay to ask questions? Okay.
Yeah, go for it.
So I could take my copy of Harry Potter and type all of these, the whole book myself. So what's the difference? That the fact that it came from the generative AI, is it different from like a person typing the whole thing out?
The problem is that you've trained on it. And yes, so it's not different. It's not different from if a person typed out all of Harry Potter and then tried to sell it, right? It's really the act of trying to sell that to a third party, monetize it in a way that is sort of without permission from the original author. There are some nuances in sort of how we treat algorithms versus humans in some of this analysis. I won't get too deep into it. It sort of gets complicated from a legal perspective, but generally, if it's not that different, right? Because really the problem is the act of selling somebody this service of I'm going to type out Harry Potter for you, right? If you hired somebody to just read you Harry Potter or read everyone Harry Potter at a mass scale, going to be a problem too. In fact, there's all sorts of copyright cases where, for example, bars playing music is a problem. And it used to be, and maybe it still is to some extent, like you'd have lawyers that would go sit in bars and try to catch them playing a copyrighted song without permission, right? And litigate that. And so it's sort of the same problem regardless. The problem here is that you have this like much larger scale and you're potentially marketing it to a lot more people, right?
Thank you.
Yeah, there's also a distinction between non-commercial and commercial. Non-commercial is considered in the fair use process. If you have a non-commercial model, a non-commercial system, it is not a free pass. Like, it still could be a problem, but it's definitely taken into account. So if you release a model under a non-commercial license, it'll be taken into account in this fair use analysis. And so there was a follow-up work actually in the last few weeks that also did something similar, but from a different angle, and looked at memorization of copyrighted books. Though some of these are by now public domain, but nonetheless, some of them are copyrighted, and basically found that if you try to do a closed task, which is like fill in the blank, a lot of these books are very heavily memorized by some of the more recent, more powerful models. And in fact, they also find, like we do, that that memorization is correlated to sort of popularity in data sets, in search engines, and from what we know about deduplication and the importance of deduplication and memorization, and deduplication's connection to memorization, this sort of makes sense, right? If things appear more often, if they're more popular, you will memorize them. You're more likely to memorize them. And so this is potentially part of where the issue comes from. And so, one side of it is to think about what can the models do, what can they generate, but the other side is to also think about how will users use the products and what will they try to generate. If users never really try to get any copyrighted material out of it, and it's very hard to do so, it's a pretty low risk. Maybe you output the copyrighted material some of the time, but damages will be relatively small, and there's like all sorts of other considerations there. So how do users consider that, or how would users use this? What we did is we looked at Crea AI, put together a data set from a Discord channel that generates art. And we looked at what sort of named entities people asked for in their prompts. And what we find is that by far, and there's some error rate to these named entity recognition systems, so take this with some grain of salt. But what we find is that there's a lot of asks for people, right? And in particular, there's also asks for works of art. So they're asking for particular names of works of art. So what does that breakdown look like? So on the people side, and again, we have some error rates. So the top categorized person is actually ArtStation, which is not a person, it's an entity. It's actually a company that hosts art. But this was the top sort of appended entity that people asked for. And after that, there's a bunch of different artists, right? There's all sorts of artist names, and people are basically trying to get art either in the style of that person or trying to make sure the generations are similar to the artwork of that person. Now, style at a high level, just general stylistic features can't really be copyrighted because you can't copyright ideas. But if there are features that are very close to the original art, then we start to get into this gray area where fair use is maybe not so guaranteed anymore. And similarly, when users ask for things that are classified as art by the named entity recognizer, we find a lot of things like Star Wars, Twin Peaks, League of Legends, Cyberpunk, all these actually sort of like name brand IP that people are asking for things along those lines, right? And so we see a little bit more risk on this front as well. And there's all sorts of other copyright considerations that I won't really dig into, but I want to mention them because they will play into the technical mitigation strategies that we want to think about. Right? So first, the Digital Millennium Copyright Act is this law that has two key features that will come up. So first, there's a source attribution sort of, it's not really source attribution, it's more of like including licensing information, but to some extent that licensing information is about source attribution. And so if you verbatim copy something that has a license that's supposed to be attached to that work, and then you remove that license, that can be a problem under DMCA. And actually some of the recent litigation focuses specifically on that component because when you generate a derivative product, right, you've sort of removed the license, right? Because it's very difficult to create a generative model that also includes the right license to the right work that it's relying on. But one of the key things here is that there is some differences across courts and how they interpret this across circuits. And in fact, some courts consider that if you create a derivative product that is different, it's transformed, you don't need to also have that attached license. And so there's some, we will see how it plays through the courts, basically, whether that holds up or if things change. And also importantly, the DMCA provides safe harbors, right? So if you have a platform and you have users upload content, right, and they upload some copyrighted content, you have a chance to take that down before getting a lawsuit, right? So you have someone file a complaint if you have a registered agent, and then you have the opportunity to take it down. But some recent litigation suggests that if you have models involved in this process, involved in curation, selection, generation, it might not be true that the DMCA applies, right? And so that is uncertain, not guaranteed. It could come out either way. We will see. But it means that fundamentally, we need to take a step back and think like, okay, we don't necessarily have this mechanism to just take things down. Even if we did, what does it mean to take down content from a model, right? Does it mean you have to do some sort of model editing technique that there's a lot of research on? Does it mean you need an output filter that filters that exact output? Or does it need to filter all outputs in sort of a epsilon space around that particular work, right? And so it's really unclear how you would apply DMCA takedowns to generative models. And it's also unclear whether it even can be used. Also important to consider is that facts are not copyrightable. So in an ideal situation, you learn all the facts and you don't learn how the exact creative expression that organizes those facts into sort of this copyrighted form. You just learn the facts. And then you have a lot of freedom, right? Like if it's factual content, you can't really copyright it. Similarly, parodies are actually okay, but it's also kind of unclear. What is it like? The parody doctrine is sort of grounded in free speech doctrine, and that is sort of unclear whether language models should have the right to parody content and things like that, and you get into sort of philosophical discussions. But also, from our sort of anecdotal small-scale experiments, it seems like language models don't really understand what a parody is, right? Sometimes if you ask for a parody, it just gives you a summary, and you're left thinking, well, this isn't very funny.
GPT-4 or GPT-3?
I think we tried both. It still is not very good. Again, like I mentioned, some other countries don't have fair use, so there's really no guarantees in those places on sort of this front. There is a push to have more fair use like standards across many different countries. Unclear how that will go, unclear how different doctrines will apply. Canada has fair dealing, but it's a very different doctrine and could come out in a very different way from American fair use analysis or US fair use analysis. And there's a lot more considerations in our paper that I encourage you to check out. There's questions about how liability shifts around. So if you're a model creator versus a model deployer versus a model user, how does that liability transfer through around different actors? And there's also some interesting questions that some have pointed out to us about basically sovereign immunity. So like state universities might be able to just sort of have at it because state universities have sovereign immunity. So there's some questions around that, and if you're at a state university, you can push those questions a little bit more. So that brings us to the ongoing litigation, right? So right now there are many different lawsuits about IP and copyright in foundation models. For example, Getty Images sues Stability AI. One of the images in their complaint is this one. So on the left is some image from their repository with their watermark. And on the right is a generated image that they say is too similar, right? And in fact, it also includes their watermark, right? Or a distorted version of it. And so there's some questions here, right? If you think back to the different fair use analyses, is this generation covered if we think about that doctrine? It's sort of unclear, right? There's a lot more complexity to the situation, but really we want to avoid the situation where we're in this like gray, murky area to as much as we can.
So sorry, going back to the parody thing, I just gave GPT-4 several parodies for the ones you list in the paper that don't work, and it does for all of them.
Okay. I mean, yeah, there's also a challenge in terms of model checkpoints over time, right? It could be that the model was updated after.
So I guess it's possible 4 was updated. I guess that seems less likely to me. I don't know.
Yeah, I mean, there's continuous updating of the model. So I don't remember, we have it in the paper which month and version we tried. So, you can check that out. But I think also we don't have a good systematic analysis in terms of like understanding of parodies. And I think sort of that would be an interesting thing to figure out, right? Like systematically.
So it looks like you're doing ChatGPT 3 only.
Okay, yeah. So yeah,
okay,
so it could be like the difference between 3 and 4 in terms of like reasoning or understanding.
Okay.
And so, yeah. But I think we did a search and we didn't find any like systematic analysis of like understanding of parodies and whether parodies are generated properly and things like that. And so I think that's an interesting question that is sort of unsolved. But yeah, so we have a lot of lawsuits across different fronts. I will note that the image generation ones are about copyright infringement. The GitHub Copilot lawsuit that is about GitHub's sort of Copilot product is not about infringement, is actually about that DMCA section about attribution, as well as a few other different doctrines. There is a particular reason for this, I think, strategically. Code, it's much harder to win an infringement case on code because ideas and algorithms and things like that are not copyrightable, which means that to win an infringement claim on code, you have to be a lot closer to like verbatim generation, and also on a much larger scale, right? There's a Google v. Oracle case, which basically says like you can have some amount of copying that's for example, API definitions and things like that. It gets a little bit more complicated. I won't get into it, but there's some reasons strategically for why you might see different types of lawsuits and different types of domains. And so where does that bring us now? It means that all these issues are going to be litigated, right? This is a very uncertain area in the law, and when there's uncertainty, there's a lot of litigation because things want to make their way up to the Supreme Court to get more certainty. And so that leaves us with a lot of potential outcomes, right? It means that you could have a district court that comes out and says, look, I've seen this model. I think it's never fair use. This seems not transformative. We're just going to close the door on foundation models. Or you could have another outcome, which is it's always fair use, no matter if you just train on like one book and generate that book, right? And so that's not an outcome we want either. So we want something probably more nuanced. And in fact, we want to make sure that we don't get these extreme possibilities in litigation, right? So that brings me to part 2, which is technical mitigation strategies, right? We want to employ technical strategies to make sure we're sort of in fair use land and not potentially having these extreme outcomes. So I'll talk about a few different strategies, but and so I'll try to go through it fairly quickly. But keep in mind that we actually have a lot of research to be done here, and I'll point out where those research opportunities are. And I think it's going to be a little bit interdisciplinary, right? We need a better understanding of the law encoded in some of these technical strategies, and vice versa. If we have better technical strategies that can help us inform the law. So there's a lot of exciting sort of interdisciplinary research to be done here. So first up is training data filtering, right? So the obvious solution is you rely on public domain data, right? And then public domain data means that nobody can assert sort of infringement claims against you, and that's great. We can train on it. Unfortunately, a lot of public domain data is mainly before 1927 or government created data by the US government only. And so that leads to a lot of potential biases, right? You could rely on Common Crawl. So Common Crawl in particular does a lot of things to try to make itself fair use, right? So you have a snapshot of the internet. They actually don't crawl every web page. They only crawl some web pages on any given website. They only take some snippets, things like that. They compress it into a non-human readable form. They do a lot of things to try to make it sure that it's fair use. In particular, one of the things they do is they respect the robots.txt files. So a robots.txt basically says what things you can and cannot crawl on a given website, right? And there is some case law, though it's only at a district court level, so it's not necessarily binding, that might suggest that this will be taken into account in terms of a fair use analysis. For example, if you ignore a robots.txt and train on stuff people sort of have said, you should not crawl this web page, and you crawled it anyway and then trained on it, that might be more problematic. Again, TBD how the courts will assess this, but some case law suggests that that might be the case. Similarly, others have suggested sort of opt-out mechanisms. Part of the robots.txt analysis is thinking about this opt-in, opt-out framework, right? If you're opting out and you don't respect that opt-out, then that is problematic. And so if you think about opt-in, opt-out frameworks, that might also be considered in this analysis. So you might think about that in terms of filtering, so removing opt-out. And then there's sort of all this discussion about memorization. And of course, deduplication will help you because you'll be less likely to memorize. So there's all sorts of filtering mechanisms you can do. But there are some challenges, and I realized that for some reason the format got messed up, so I'll just talk through it. So basically the challenges are that none of this is guaranteed, right? Deduplication does not give you a guarantee that you won't memorize something. Just because somebody labels something as public domain doesn't mean that there aren't things in there that are not public domain, right? People mislabel licenses a lot, and things that seem like under a permissive license might have content in there that is not actually permissively licensed. So you can think about a web crawl, right? Somebody puts up a pirate website and it hosts all the books in the world. And they say, go ahead, crawl my website, I don't care. And you do it and you train on it, right? They seem to have provided you with some, permission to some extent, or maybe they even explicitly label it as public domain, but actually it's not because they don't have the rights to any of that work that they hosted, right? So it's very hard at the scale that we're working with to make sure that things are permissively licensed. And in fact, it's almost impossible. And so you have no guarantees here, but, as if you put in a lot of effort, and you can actually try to reduce the risk quite a bit. And also, right, if you're relying on public domain data from before 1927, that is a very different world with a lot of biases, not necessarily something we want models to be exclusively fit to. So you can also rely on prompt filtering. So for example, remember we had what people ask for in terms of prompts. They ask for works of art. They ask for particular artists. You could do something, and in fact, Google does something like this, where you have audio LM, which is or it's either audio LM or music LM, I forget the name, but music LM, sorry, it's right here. So music LM has this sort of experimental version, and you can ask for creation of different music, but if you try something like in the style of Drake, it will give you an error, and in fact, the agreement says you shouldn't try these sorts of things, right? And so you can filter for those sorts of prompts to make sure that you're not allowing users to potentially ask for things that are potentially infringing, right? And so you can do this for GPT-4 as well. If you ask it to read me Harry Potter, it'll say, I'm sorry, but I'm unable to directly read copyrighted works like the Harry Potter series, right? But if you try our different prompt from before, where you just give it the first 4 lines with some, perturbations, it'll do it, right? And so there's a challenge of over-filtering, right? Like style is not always protected. Maybe it's okay to have, some of these asks to some extent, but also exact matches don't cover all scenarios, right? Prompt hacking is a real thing. People will try to prompt the model in different ways and recover the thing that they want to get. So you could try output filtering instead. So actually now, if you try GPT-4 with this prompt, so this is sort of prompting with chapter 1 of Harry Potter, you will actually see what it does is it starts to blink and it says, Mr. Dursley was, and then just blinks for a while and then it just stops generating, right? And other people have found the same behavior. I don't know for sure, but I suspect it's a filter. And what's happening is you're checking for exact matches, right? And that's a reasonable strategy to prevent the sort of exact match verbatim memorization issue. But the problem is, again, I can give the same prompt with a little bit of an instruction saying, continue the above, replacing A's with 4s, and then we get our 3.5 chapters again, right? And so, again, with output filtering, you need to make sure that these perturbations are taken into account. And it's not just this prompt hacking, it's also just generally, right? Like the model might replace the first 3 words with some different words. It might paraphrase some aspects of the work that still wouldn't be fair use, but nonetheless, the filters won't catch. Some others have pointed this out, that verbatim filtering is not necessarily going to cover all these use cases. And also there's a question in terms of like, if you're not doing verbatim filtering, what is the similarity metric that you should be using that captures transformativeness in the fair use doctrine? So captures those cases that we've talked about before. You might also think about instance attribution to get around the DMCA problems. So for example, you might have 3 different books, you might train on them, and then you might output, the places you'll boldly go, and then you'll say, okay, where did this creation come from? Which source should it be attributed to? And, it might get attributed to some Dr. Seuss or something like that, right? But there's challenges here. Scalability in terms of instance attribution techniques is sort of an unsolved problem, right? Figuring out which training data affected which outcome is a very computationally complex problem. There's some new research on this, but it's an exciting time to figure out how to do this. But there's also questions of accuracy and interpretability, right? You want to make sure that you're actually giving credit to the right thing, not just similar things that actually affect the generation of the model. Because when you think about it from like a legal context, you're going to have humans trying to interpret, what does this instance attribution mean, right? What does it mean that I used 5% of Cat in the Hat in terms of like generating my output? Does it mean that I lifted 5% of the content? Does it mean I took uncopyrightable things from it? Did I take some facts that I learned from that book? Did I take some high-level ideas that really are so commonplace that they're not going to be copyrightable? Or is it that I took 5% of copyrightable things, right? So there's these different levels in the semantic space that you're thinking about in terms of attribution. And I think it's important to think about that as we design different instance attribution methods. There's getting to some differentially or close to differentially private training techniques. You can do near access free training. This is sort of a new technique proposed this year, where you shard the distribution of data. You ensure that the final model only outputs things that the submodels trained on shards would. And I'll sort of walk through that really briefly. Basically, you partition the space and you have 3 different books: Harry Potter, Cat in the Hat, Lord of the Rings. You create 3 data sets from those books. You train 3 separate models on those books. And then when you merge it back together, you only keep content that would be generated by all 3 of those models, those submodels. So that way, you'll only get like high-level themes, like things that would be in common between Lord of the Rings and Harry Potter, not things that would be unique to either. Similarly, you could think of a differentially private training approach where you deduplicate according to some copies of the same copyrighted work. you use DP techniques to ensure that that work remains private, so you can't generate it verbatim. This is not the DP portion, but the deduplication portion is sort of similar to what DALL-E 2 does for pre-training mitigations to some extent. They basically cluster, according to some similarity metric, a bunch of different works together, and then they keep only one of those works, right? And so I think to use something like differential privacy or this near access free, you need to do something similar where you cluster according to a similarity metric and deduplicate according to that metric. The challenge for both of these approaches is basically this deduplication is actually more of a challenge than you would think, right? Because if you think back to our example of the tattoo on a game player in a video game, right? You could have a bunch of different images of that NBA player across all the shards because it's really hard to deduplicate that tattoo across all shards, right? And so you will probably memorize that image of that tattoo unless you have a fuzzy deduplication metric that can take that into account. And in fact, it is probably very difficult to deduplicate and get guarantees at that level, right? So even though this will definitely help, you will prevent memorization to some extent, you will have some issues in terms of getting guarantees. And ideally, you want guarantees at some higher level semantic space, right? The places you'll go versus the places you'll boldly go. You need to make sure that those are, taken into account. The fact that you can have these two different things that are not fair use that might look very different at a low level similarity space, but actually at some different high level semantic space are aligned, right? And so we need to think about that both within this in terms of differential privacy and near access free, but also within all the other strategies that we're taking into account. I'll also mention one last one, which is learning from human feedback, right? Again, GPT-4, for example, will respond to the prompt saying, I can't read you copyrighted books. So if you have a good understanding of the law and you have models that can reason about the law, you can also sort of learn from that and create responses. Or you could learn a metric for fair use and say, actually, when I'm doing RLHF, when I'm reinforcement learning from some reward model from human feedback, I should take into account the fact that I actually want to optimize for some level of similarity, but not exact matching anymore. I don't want exact matching. I want something that's more like fair use, aligned with what the general public or lawyers or the judiciary might think of as transformative, right? And so you might say, I want to keep the facts and actually have like a totally different structure and outcome and thinking about that. And so there's some challenges here. Again, you need a good understanding of the law or a good training set to catch these sort of asks for copyrighted content. And you need to make sure that if you're optimizing for a fair use like metric, you actually need a good understanding of fair use, right? And so that's actually not something that we have. We don't have a good understanding from an empirical perspective of how people would judge fair use. And I think that's a really exciting direction. And so I think there's actually a lot of really exciting research here at both a fundamental technical level, at an interdisciplinary level. So we can use machine learning to build a better understanding of the perceptions of fair use, right? We can build better models of that just to help us understand what is the law, how do people think about this? And then that will help guide some of these mitigation strategies. We can build more transformative models, which is just really exciting, building more creative models by making sure we extend to that transformative space of things. Separating facts from expression, which is critical for thinking about fair use, might also help with things like factuality. If you have a good way to memorize facts without memorizing the broader piece of content, that's a really exciting line of research that could help with other problems as well. And I also think from a differential privacy perspective, I think it's pretty exciting to think about the potential ways to implement differential privacy where you have these different groupings where you might want private information at different levels of semantic spaces. And I think that's a kind of an unsolved challenge, but also a really exciting, interesting technical one. And the reason to pursue all of this, beyond just it's interesting, is that better technical mitigations means that there's less likely to get broad extreme outcomes in court, right? So if you have a lot of mitigation strategies and you've really narrowed the space of what sorts of not covered content is presented to the court, we're less likely to get these sort of extreme outcomes. And then we're running out of time, but I'll just briefly skim through. There's also lots of law and policy considerations, right? We have a lot of shifting and murky doctrine here, unclear if DMCA is covered, unclear how fair use will be assessed. So it might be worth having policy interventions to think about, what does a DMCA safe harbor look like? Should it be tied to the strength of technical mitigations? What does that actually mean to take down content and thinking about policy interventions in the space? Even if all model deployments are covered by fair use, what are other potential harms? How do we address these, right? It's unclear that we want everything to be covered by fair use from just sort of a higher, broader level societal perspective. So how do we think about that in terms of both the development of the doctrine and in terms of development of other policies that might address things that fair use either doesn't or shouldn't address? And if we go towards a mass licensing mechanism, so we say, okay, actually, we should just license everything. How do we make sure that creators are the ones actually getting the benefit, right? There's a lot of cases in history and the law where we see a lot of intermediaries get all the benefit from those mass licensing schemes, and creators still get, not a whole lot from that. And so as we're thinking about policy interventions, I think there's a lot more research there to be done to think about really good policy interventions. Okay, that's it. Thank you so much.